Hello aspirants, welcome to LawCET Adda, India's best institute for Telangana and AP LawCET exams. Now, today we'll be discussing about the 2025 PG LawCET exam PYQs, PGLCET. Right? In this particular video, we'll be focusing upon the kind of questions that were asked in the exam and how analytical it was, and how we can eliminate the options, as well as how we can arrive at the right option that we'll be discussing in this particular video. So without wasting any of our time, let's quickly proceed into the particular session. Now the first question says, who has defined the law as the prophecies of what court will do in fact and nothing more pretentious? Now the correct answer for this question, the particular thinker here, is Oliver Wendell Holmes Jr. Now, if we talk about little bit about Oliver Wendell Holmes Jr., he was a famous American jurist. He belongs to American School of Jurisprudence. American school, when I mention American school primarily focus upon realist school. See, what is meant by realist school? Here, according to him, the law should not be understood merely as an abstract rules written in books. No, he's not talking that law you should not study what it is written in the book. Rather, law is what court actually do in practice. What they do in practice, right? It simply means that how law is implemented in practically. His famous statement, this means that if the person wants to know what law really is, he should look at how judges decide the cases in reality, right? How judges actually focus upon the cases in reality. That should be the primary point of discussion, rather than you are reading the law in the books. So from the Holmes perspective, the prediction of the court decision is the true meaning of the law. So here, when we look at judges are working in the court. Now court, how it decides the law. So this is kind of a prediction, nothing but interpretations of the law. So this particular theory is also, this idea is also known as a prediction theory of law. This is also known as the prediction theory of law. Right? Understood? This is a prediction theory of law. So this is what we can infer from the Oliver Wendell Holmes Jr.'s idea of prophecies of law. Right? Now, the next question, it talks about that the motto of which school of jurisprudence is ubi civitas ibi lex. Right? Now what does it mean? Now when we understand this Latin phrase, then only we will arrive at the right conclusion from this particular thing. Now the correct answer for this is analytical school. Now what is this ubi civitas lebi means? Now it means where there is a state. Where there is a state, there is a law. There is a correlation of law. Nothing but a state is an established authority. Established authority will make the law. The idea is closely connected to the analytical school of jurisprudence. Also, this is also known as positivist school. This is also known as positivist. Right? Analytical school is also known as positivist school. Now, analytical school believes that law is created by the sovereign or a state. Now, generally we say state or sovereign. Sovereign authority is the one which is established by the people, or which is established, which derives its power from the will of the people. Right? According to this analytical school or the positivist school, law does not depend on the morality. It does not depend upon morality. No, it does not depend upon the morality. Law does not depend upon customs. Law does not depend upon the religion. What matters is whether the rule is officially recognized and enforced by the state. Now, in this particular school, the thinkers like John Austin emphasized that the law is a command of sovereign. It's a command of sovereign backed by sanctions. Backed by sanctions. What does it mean? That if some person is not implementing the law, then obviously the person will face certain kind of punishment, face certain kind of fines, etc. So that is why the motto, where there is a state and there is a law, perfectly this represents the analytical school. Right? Understood? Now, the next question, it says, who is the author of the book Law in Making? Now, the correct answer for is Carleton Kemp Allen. Now, let's see what the Law in Making, the book, discusses about. First of all, the Carleton Kemp Allen is one of the renowned jurist and a legal scholar. His famous book is Law in Making. Now, he is considered one of the most influential books in the jurisprudence and the legal theory. In this book, actually, the Allen explains how law is not static. According to him, law is not static. Rather, but it is continuously evolves with the society. It evolves through the judicial decisions, evolves through customs, evolves through legislations, right? If you understand, the law is not something static. It evolves. It evolves with customs, legislations. It evolves with the social changes also. It evolves with social changes, right? He emphasized that law develops gradually with the society. It develops gradually with the society, right? And also with the practical needs. Law develops with practical needs. Done. Now, this book actually important in understanding the growth and development of the legal system, because the particular book discusses about the law is not a static in nature. As like analytical school, it's not a static in nature. It evolves with the society. It evolves with the custom, right? It evolves with the other aspects of the state. Now, the next question, if we discuss now. Who said case law is a gold in mine, a few grains of precious metal to the tons of useless matter, while the statute law is a coin of the state where is ready for immediate use? The correct answer for this is that John Salmon. Now he said this particular lines. Now what is meant by that? Now John Salmon used this beautiful comparison to explain the difference between case law versus the statute law. Difference between case law versus statute law. Now, according to Salman, case law is like a gold. It is a gold hidden inside a mine, right? When you hunt for the gold, what happens is that a lot of mines will be there, right? In that mine, only few important places where you can find the gold. The rest of things are not useful. Now, likewise, here case law is like, if you want to get any information from the case law, then you have to read a lot of literature, a lot of things that is said by the judges, etc. But finally, you will arrive at a small point, that is through the conclusion, right? The judges and lawyers must carefully search through many judgments to discover the useful legal principles. It requires the interpretation and the extraction. On the other hand, when it comes for the statute law, which is directly enacted, which is ready-made, like a coin issued by the state, right? It clearly written, officially enacted by the legislature, and can be directly applied. Through this statement, Salmon actually highlighted the practical advantage and the clarity of the statutory law, while also recognizing the value of judicial precedents, right? He gives an importance for the judicial precedent that has been there. What is judicial precedent? Judicial precedence is the one where judges given certain kind of opinions on the particular judgment, and that will establish for the future cases on the similar matters, right? Judicial precedents were given important thing here. The next question is that which jurist believed that criminality is closely related to the possession of certain physical qualities, as it is the atavistic phenomenon. Now, what is this particular thing? Before that, who said this? This actually said by Cesar Lombroso. Now, who is this person? This person is a father. He's considered as a father of criminology. He's a father of criminology. Right, he's a father of criminology. Now, he is also the founder of Positive School in Criminology, right? Positive School of Criminology. Now, he developed the theory called born criminal. Now, what is meant by born criminal, etc.? Now, let's see. According to Lombroso, some individuals are born with criminal tendencies and can be identified through physical characters. Now, he's saying how to identify the criminals. It is through the physical characteristics. What are the physical characteristics he's talking about? He's talking about the skull shape. Look at the skull shape, how it is. And he's saying about, look at the large jaws, how the jaws are present, and long arms and other bodily feature is physically describing it. Now, what is this atavistic phenomenon means? It means meaning a person may display primitive or ancestral traits. Okay, it's a kind of primitive or ancestral traits. For example, when the human beings are evolving in the initial stages, right? Now, the human evolution starts from hunter-gatherer society, etc. like that. So, if you understand this hunter-gatherer society where the human tendency is to what? Hunt, gather, etc. So, atavistic phenomena is that symbol that is being shown. In simple words, Lombroso believed some criminals were evolutionary throwbacks, nothing but they still remove that primitive and they carry back and they carry to the modern civilized society, because obviously the crime happens. But if you look at, although this modern criminology has largely rejected this biological determinism, right? So initially it was thought there are people who are criminal tendencies have from the birth, but the society over the period of time realized that is not the case, right? But still he is an influential person in terms of his work. Done. Now, moving to the next question. Now the question says, who distinguished expository jurisprudence from censorial jurisprudence? Now, there is a distinction between expository versus censorial. Now, who said this? This was said by Jeremy Bentham. Now, let's see who is Jeremy Bentham and why he is saying this. And Jeremy Bentham is very famous for his utilitarian school of thought. He is very famous for utilitarian school of jurisprudence. Now it clearly distinguishes between these two concepts. Now that is the expository and sensorial. Now what is this expository? Explains that law, what this particular school or particular jurisprudence talks about is that it talks about law, but law as it exists. Law as it exists, nothing but how the law is existing in the society. It describes the actual law in force without judging whether the law is good or not. It is not judging whether the law is good or bad, right? It is not judging that. But when it comes for the sensorial jurisprudence, it discusses the law. It discusses the law out to be, how the law it should be, law out to be, right? That is been taught here. Now it evaluates the law based upon the utility, it based upon justice, it is based upon social welfare, and suggests the reforms where necessary, right? That is very important. This is sensorial part. Now Bentham's believed that the law should promote the greatest happiness of the greatest number. This is a very famous line. This can be another question here. The utilitarian principles, greatest happiness for the greatest happiness for the greatest number. That is what it has been discussed here, right? Now this is the core principle of utilitarian school. Now what is this greatest number of greatest happiness? Is that in a society not everybody will be happy. Now law should focus upon making the larger section of the people happy, right? So this is what it has been considered. Now this clearly distinction is very important in the legal philosophy because it separates the study of existing law and the criticism or the improvement of the law that is required in the society, right? Done. Now the next part or the next question is that as per Hoffield analysis, the presence of power in a person implies the absence of dash in another. Now see, this is very important. The answer for this particular question is immunity. Now let's see what is this question is actually talking about. What are the concepts involved here? To understand this, we need to know what is this Hoffield analysis or the concept of legal relationship. Now he is giving something called legal relations. Now, what is this legal relations? He gives the legal concepts. He gives the legal concepts in terms of pairs. Now, what is that pair? The pairs are existing in correlatives. They are existing in correlatives, and they are existing as opposites. Right? They are existing as correlate. Correlate is nothing but one correlates to the another. Opposites are nothing but the laws or opposite either. Now, he goes on to explain that power in one person. Power, somebody has a power, it corresponds to disability in other person, right? If somebody is powerful, the other person is having certain kind of disability. The opposite of power is also is a disability, right? The opposite of power is a disability. If somebody has a power, he has a kind of liability on the other person, and the opposite of the power is a disability. Similarly, immunity corresponds, nothing but it's a correlative of disability, right? Now if one person has a legal power to alter another person's legal position, then another person cannot claim immunity. So let's take an example now. Now, if a court has a power to impose certain kind of legal consequences on a person, for example, a court is imposing certain fines on the other person, the person does not have the immunity against the court authority because court has established, it went to the process, trials, everything has taken place, due process has taken place. Now court has imposed certain things on the person. Now person has no remedy. Now he has been disabled or he has no immunity. So that's why the presence of power implies the absence of immunity. So this is the concept, which is a larger discussion that is required, but for this particular question, this is enough, right? Understand the correlatives and the opposites that is given Hoffield's analysis, right? The next question is that who referred to jurisprudence as the eyes of law? Who referred this eyes of law? Now the correct answer for this, Harold Lasky. Now what he is describing about the jurisprudence, he is saying that jurisprudence is like the eyes of the law, because jurisprudence helps us to understand deeper meaning. It helps us to understand the deeper meaning. It helps us to understand looking at the purpose of what law serves for, and also talking about the functioning of the legal rules. It talks about functioning of the legal rules. Just as the eye helps the person to see clearly, jurisprudence helps lawyers. Right? Jurisprudence helps lawyers, jurisprudence helps judges, jurisprudence helps scholars, right, to analyze and interpret the law properly. It provides the theoretical foundation behind the legal principles and explains the concepts such as rights, duties, justice, sovereignty, and legal institutions. In simple words, jurisprudence give what? Jurisprudence gives clarity and vision. Jurisprudence gives clarity and vision to study about the law, right? Study of the law. Done? Now, the next question, who is the proponent of bracket theory relating personality in law? See, What is meant a personality? Personality is a person who is having certain soul, body, flesh, etc. But when it comes for the law, there is something called as artificial legal persons that is created. It's a pure creation of the law, right? Now, for this, who proponed this? This was proponed by Rodolph von Eyring. Rudolf von Eyring is a person who proponed this. He proponed the bracket theory. This is also known as, this is an additional information, this is also known as symbolist theory. This is also known as symbolist theory, right? Symbolist theory of legal personality. According to this theory, the concept of a legal person is only symbolic, right? The concept of a legal person, what is this concept of a legal person? This is very symbolic in nature, or it's a kind of convenient way of describing the rights and duties of real human beings, right? In simple words, corporations or institutions do not have the real independent personality of their own. Their law simply places bracket around these legal entities, right? Or not, legal entities are in a group together as a bracket for the group, for the namesake, for convenience sake, right? For example, when we say company owns property or enters into contract, the actual beneficiaries are the human beings who are working behind the company, right? It's not the company as such which is doing all these things. Thus, the legal personality is treated as artificial legal device. This is what very important. This is artificial legal device. Done. Now, the next question says that in which of the following theories judges are no more than a discoverers of law. What does it mean? Now let's look at the meaning. First, let's see which theory says this. This is actually said by declaratory theory. Now what does it mean? So according to the declaratory theory, judges do not create new law. Judges do not create new laws, right? Their role is only to discover. What they discover, declare and apply the existing laws. They only do with respect to existing laws. Whatever it is there, they will do with respect to the existing laws, right? Now, this theory was strongly associated with the jurists like Blackstone, etc., who believed that the law already exists. Customs exist, principles exist of the society. What judges do? Judges merely identify. They simply identify this. Right, they simply identify and declare it through their decisions. Right, it is declared through their decisions. In simple words, judges are viewed as interpreter of laws. They are viewed as interpreters of law, interpreters of the law, not the lawmakers. They are not lawmakers. Right, where lawmakers are present in parliament, state legislature, and what of the authority that has been established. Right, for example, when the court gives a judgment, the theory assumes the judge is simply uncovering what the law has always been. Right, done. Now the next question is that according to whom animus domini is an essential element of possession. Now what does it mean? Now this is actually given by Carl von Savigny. Now what he says, etc. Let's see. Now actually the Savigny belongs to historical school of thought or historical school of jurisprudence. He belongs to historical school of jurisprudence, and he developed this classical theory of possession. What is considered as possession and what are the essential features of the possession, etc. So according to him, there are two types of possessions. Now one is corpus possession and second is animus possession or animus domini. Now what does this mean? Now, corpus possession means this is a physical control. You are physically controlling something, right? You have physical control on certain thing. Now, animus domini is that the intention to possess. Now, you are thinking about the intention to possess something of an object as an owner. Now, this term animus domini means the intention or the mental element. This is a mental element to hold the property as one's own. This is a mental element to hold the property as one's own. See, Savigny believed that the mere physical custody is not enough for the possession. A person must also have the intention to exercise. They should also have the intention to exercise the ownership like control over the things. Now, merely saying you are the owner and also acting like owner is a two different thing. For example, let's see. A servant is holding goods on behalf of his master. There is a master and there is a servant, and servant is holding certain kind of goods. Now, his master has the physical custody of this, right? But not the possession, because he lacks. Master has a physical possession, but who is acting? This is a servant is acting. Now, what is master is lacking? Master is lacking aminus, right? Aminus domini. Understood? Yes. Now let's move on to the next question. That which of the following reflects the John Locke's theory of property? Now let's see. Now this among all the statements, the right statement is mixing one's labor with the nature justifies the creation of the private property. Now let's see what John Locke and why he is giving this theory of law. Right now, John Locke is a famous philosopher Now he belongs to the natural school, very important. John Locke belongs to the natural law school or natural school of jurisprudence or natural law school, believed that every person owns his own labor. Now he believed that every person owns his own labor, right? Nobody can control his labor, but every person has his own labor. When a person mixes this labor, that labor with the natural resources, for example, there is a land and person involved in certain labor, for example, plowing, sowing the seeds, watering the plants, etc. Now, according to this natural school, it says that since you are invested your labor with the natural resources that is present, now you own the property. Now you own the property, right? So this is what it is said. For example, if a person cultivates unused land, grows crops or cut timber through his own efforts, he acquires the ownership over it because of the labor invested. The idea is known as labor theory of property. This particular is known as labor theory of property. Locke actually argued that the property rights arise naturally from the human efforts, not merely from the state authority. He says it's not the state which gives the right to property. State does not have any authority right to property, but it is the naturally that is flown to the human beings, right? So this is a natural school that gives the idea of property. Now next part is that ratio decidendi means what? Now here the correct answer for this particular is that statement 1, 3 and 4. Now let's see why it is and all. Now first of all, let's understand what is this ratio decidendi. This is a Latin maxim which means that the reason. Now this means that the reason for deciding the cases. For deciding cases. Now what does it mean? While judge giving any kind of judgment, he should also give the reason for this. What kind of judgment is being given, right? Mere observation is not the judgment. Mere observation is not the reason. Mere observation not the reason. For example, judge simply saying certain things on the case, that is not a binding one, right? Binding rules and regulations are part of this reason. Now let's see the statement 1. It is correct because ratio decidency is a reason on the basis of the decision, right? It is a reason or the basis of the decision. Now you look at the second statement, general observation. General observations are not part of it. Now if you eliminate the two options, you actually arrive at the right answer. That is the fourth option. Third statement also correct because it becomes the binding rule. It says it's a binding rule, right or not? It's a binding authority of the lower courts must under the doctrine of precedence. Now the statement 4 is also correct because the principle applies not only to the present dispute but also to the future similar cases. That is what judicial precedence means, right? Future disputes also. It also applies to the future dispute, present dispute as well. That's where it has been set upon. Now the next question is, according to Salmon, custom is dash of the law. Now custom is the legal material source. Now what is this legal material source the John Salmon is talking about? John Salmon classified the source of law into different categories. Now, according to him, legal material source is a source from which law derives its actual content or substance. Now, custom is considered as a legal material source. Now, custom is something which is evolved from the society. It's a legal material source. Now, because legal rules originate from the long-established social practices. Customs are nothing but the social practices. Now, according to Salmon, he says that the legal material sources are important for the law. In simple words, the custom provides the materials out of which the law is formed. For example, many personal laws that is there in Indian society, especially Hindu law, Muslim law, etc., and the traditional practice that is existing were recognized by the courts because they are evolved from the customs followed continuously over the period of time, right? So customs are important which evolved through social practices. Now, the next question, which prominent jurist has developed the will theory of rights? Now, the answer for this particular question is that H.L.A. Hart. Now, who is he, etc.? Let's see now. Now, the will theory of right explains that right gives a person the power or the freedom to control another person's duty. Now, if somebody has a right, now certainly the other person has certain duty because one person holds a right. For example, A and B enters into a contract regarding the construction of the house. A wants to construct his house. He entered into contract with B. Now, A has a right to get his house. B has a duty to fulfill in construction of the house, right? That's what the right is there. It has to be correlated with the duty. Now this Hart strongly supported this theory and argued that the rights empowers the individuals by giving them control over the legal relations. For example, in a contract, if you take, a person may choose to enforce the legal duty or waive it. This control reflects the exercise of will. Now this theory actually mainly focuses upon the individual autonomy, how individuals behave with their right. It focuses upon individual autonomy, and it focuses upon freedom of choice. Now it focuses upon the legal control of duties. Done. Now the next question. If you look at the next question now, as per the definition given by John Austin, ownership is a right unrestricted in a point of disposition. Now he is talking about John Austin. John Austin also, we have seen, he is one of the founders of the positive school of thought. And the ownership right, it is talking about the ownership right. What does it mean? See, according to John Austin, the ownership refers to the right that is unrestricted in terms of disposition. It is unrestricted in terms of disposition. The word disposition actually means here the power to deal with property. It is a power. Now you are dealing with property, power to deal with property in any manner the owner chooses. Right? It includes, what is the any manner the owner chooses? It includes to sell the property, it includes to transfer the property, it includes to gift the property, it includes lease the property, or otherwise how to dispose the property. That ownership the person has. Right? The Austin believed that the essential feature of the ownership is the owner's complete control. Owner should have complete control over the property. He should have the complete control over the property. For example, if a person owns a house, he can sell it, he can rent it, he can donate it, he can transfer it according to his wish. This expression, this freedom of disposition reflects the ownership. Right? Understood? Now, the next part. A precedence gives per incurrum is of what? Here is a decision made in ignorance of a binding authority. Now this is the right option here. Now let's see what is this. A precedence gives per incurrum. What does it mean? It is a Latin maximum. Per incurrum is a Latin maximum which says through lack of care. Now you are giving judgments through lack of care or through ignorance. You are ignorant on something of what? It says a judgment is said to give per incurrum. A judgment or a precedent is per incurrum when the court delivers a decision while ignoring a binding statute, while ignoring an important legal provision. You are ignoring this. And also a binding precedent. You are not even taking care of precedents. Precedents are nothing but the previous established case laws, settled case laws. Now that is also not considered by the higher courts. Right? Because of such decisions, such a decision overlooks the authoritative rule. You are overlooking the authoritative rule, nothing but the binding rule. It does not have the same binding value as the properly decided precedents. For example, if the court gives a judgment without considering the Supreme Court's ruling, that would means that it is not followed the precedents, right? It is per incurrum. Nothing but simply in simple words when we will discuss that the judgments are given ignoring the precedences or established authority or in ignorance. That is per incurrum. Done? Now, the next question is that according to Henry Maine, the movement of a progressive societies has hitherto been a movement from where? It is a movement from status to contract. What does it mean? It's a very interesting theory. Let's see this. Now, Henry Maine, he belongs to the historical school of jurisprudence. Very important. He belongs to the historical school. Now, as you know, historical schools actually talks about how the societies evolved over the period of time. So, according to him, the ancient societies, a person's right, according to ancient society, talking about the ancient societies, here the person's rights or the duties, etc., it depends upon the social position the person is. It is mainly determined the social position, which is nothing but the status of the person. For example, in the ancient times, the society is divided into fourfold classification of Varna system. That is Brahmins, Kshatriyas, Vaishyas, and Shudras. Right? This is a fourfold classification, and each classified version or the category has their own rights and duties. Right? Now here it is not. He's saying the society is evolved over the period of time. It is moved from the status to contract. Now what does it mean? It means today nobody cares about the status of the person. They care about the contract they made with the other person. Right? This means the role is that it is based upon the contracts in the modern day societies. Earlier it depends upon the family, caste, birth, or the social positions. But today it is a progressive society. Individuals gain greater freedom to shape their own legal relationship through contracts and the voluntary agreements. So the modern society moved from the fixed relationship based on birth to voluntary relationship based on agreement. For example, earlier the occupations and social roles were inherited by birth. Today, people freely choose their jobs, enter contracts according to their choice. Right? This transition is what main describes the status to contract. Done. Now, the next question is that the solidarity obligation imposes dash liability in law. It is both joint and several. Now, let's see what is this. A solidarity obligation means that it means that when two or more persons are liable for the same obligation, each person can be held responsible to the entire obligation. This is known as joint as well as several responsibility. For example, A and B borrows money jointly from C. Now what happens is that B is not paying the money. C can sue A. C can sue B also. C can sue both. Now this is the joint and several. Several is individual, joint means both, right? Now in simple words, if you look at the parties are jointly liable together, each individual party is also severally liable separately for the full amount, right? For example, if three persons jointly borrows money, the creditor may recover the entire amount from any of them. The person who pays can later recover the contributions from the others, right? That's a different one. For example, A, B, C and D is a person whom they have borrowed. If C record all the money from, if the D record all the money from C, then C also automatically has an obligation to recover his part of money from A and B as well, right? This is called joint and several liability, right? It protects the interest of the creditors and ensures effective enforcement of the obligations. Done. Now, the 20th question here, it says, Oscar Wendell quote that every saint has a past, every sinner has a future, reflects the concept of which theory of punishment. Now, if you look at this is a kind of statement actually you will find in the reformative theory. Now, what is this reformative theory? This quote is beautifully reflects the idea that no person is permanently bad or no person is permanently an offender, right? And it has every possibility of improvement and transformation. The reformative theory of punishment focus upon what? This reformative theory of punishment focus upon, obviously it focus upon reformation, it focus upon rehabilitations of the people, it focus upon moral improvement of the offender. So instead of creating criminals only as a person to be punished, this theory believes that it should be focused upon educated, corrected and reintegrated into society. A person should be educated, and person should be corrected and they should be reintegrated. That is the main purpose of our the BNS also or the IPC that was there before. It was a reintegration into the mainstream society. Now this theory is based upon the belief that crimes may result from social conditions, poverty, lack of education or bad circumstances, and therefore the offender should give a chance to reform. There should be a chance for the reformation. For example, how to reform that? Do counseling to the people. There should be some kind of vocational training also. There should be vocational training. There can be some kind of education purpose that can be taken away. There can be rehabilitation programs based upon the reformative approach. Right? Now, let's move on to the next question. This particular question says, Article 43B of the Indian Constitution deals with. Now, the correct answer, Article 43B, is dealing with the promotion of cooperative societies. It deals with the promotion of cooperative societies. Now, Article 43B, some of the interesting facts about it is that it was not given in the original constitution. This was inserted by 97th Constitutional Amendment Act, which was enacted in the year 2011. This article is a part of, as you know, this article is part of what? This article is part of DPSP, Directive Principle of State Policies, and directs the state to promote what? Promote voluntary formation, promote autonomous functioning, promote democratic control and professional management of cooperative societies in India. The objective is to strengthen the cooperative movement in India and encourage the collective. It encourages the collective economic development. That is important. It encourages collective economic developments, right? Now, it talks about cooperative societies. They play an important role in important role in terms of agriculture. They promote important role in rural credit system. They play important role in dairy farming, housing and small scale industries. That is most important, right? Now, the next question, it says, arrange the following landmark cases relating to the amendment of the Constitution of India in a chronological order. This is a chronological order based question. Now the correct answer for this is D, B, A, C. Now let's see the year that was there, etc. Now the first is look at the D. D, that is that it is a case on the Bharati's case. Very famous case was the state of Kerala. This was enacted in the year 1973. And the next case is Minerva Mills case. The Minerva Mills case was enacted in the, or it was given in the year 1980. It talks about fundamental rights, DPSPs, etc. Next is a Vaman Rao case, which is of 1981. Right, and this is given some clarifications regarding the 9th schedule of the Constitution, which also said the any cases which were inserted to the 9th schedule after 24th April 1973, which is the case on the Bharati's case, that could still be reviewed if they violated the base structure. And finally, that is the year 2007, that is a IR Coelho's case. Now here the Supreme Court further strengthened the judicial review by holding that even the 9th schedule laws are subject to basic structure scrutiny. So this chronological order will be: first is Keshavananda Bharati's case, next is Minerva Mills case, third is Vaman Rao case, and fourth is IR Coelho's case. Right? Done? Easy question. Now the next question: which of the following statement is true? Right? Now among all the statement, the true statement is that the Constitution of India does not provide the establishment of the collegium system for the appointment of the judges. Now let's see what is the collegium system, etc. Now the collegium system is not mentioned anywhere in the text of the Constitution of India. It was created by the Supreme Court judgments, right? It was 3 judge cases: the first judge case, second judge case, and the third judge cases. Under this system, senior judges of the Supreme Court, the collegium system consists of senior most judges of Supreme Court, recommends and transfer the appointment of judges. The Constitution is originally provided only for the consultation between the President. The original Constitution for consultation between the President, Chief Justice of India, and other judges, right, which was given in the Article 124 and 217. 217 is for the High Courts. But the detailed collegium mechanism evolved later on through the judicial interpretations, etc. Right? Understood? So, among all the statement which is true, the second option is true here. Done? Now, when you look at the other options, anyhow, let's see other options as well. The option 1, Article 124A provides for the collegium system. No, as we have discussed, it is not given anywhere, right? This is an incorrect statement. Now, look at the option 3. It is a Judicial Appointments Collegium System Act 1999 established collegium. No, as I said, it is not mentioned anywhere. There is no act also. Now, option 4, it talks about NJC, National Judicial Appointment Commission, supplements the collegium system. No, actually, this was meant to replace the collegium system, anyone that was struck down by the Supreme Court through 99th Constitutional Amendment Act. It was subjected to, done by the 99th Constitutional Amendment Act. It was declared as ultra virus. Done. Now, the next part is that next question. Let's see. The question says, which body is primarily responsible for making the recommendations to the presidents regarding the distribution of the taxes between the center and state? It is a very simple question. It's a very easy question. That is the Finance Commission. Right or not? Actually, the Finance Commission is a constitutional body which was established under Article 280 of the Constitution. Now, its main functions is to recommend how the tax revenues shared between union government, nothing but central government, to the state governments. It also the one principles governing the grant in aid. They grant in aid. Right, that is been governed here. It and also measures to be improve the financial positions of the state. This process is known as vertical as well as horizontal. Vertical as well as a horizontal physical disposition. The vertical distribution is nothing but from the center to the states how much money has been spent, and from among the states how the money is spent. That is the horizontal classification. Right or not? Now, let's see the other things in the options here. Now, Public Accounts Committee. This committee actually examines the government expenditure and audits, etc. Niti Aayog is an executive body. It promotes a cooperative federalism. And GST Council is a constitutional body, no doubt. It was created under Article 279A. But it is not, as such, it is recommending the tax structures between center and the state. Right? It does not have any that constitutional powers here. Right? Now, let's see the next question. That in Sukanya Shanta versus Union of India 2024 case, Supreme Court held what? Here, simply remember the judgment here. It held that the provisions of the prison manuals of several states allowing the caste-based discrimination for the division of manual labor violate the constitutional principles. See, one of the degrading practices is that manual scavenging. It is not only existing in the Indian society, it also pierced or percolated into the jail system also. In the jail also, caste-based division is there. Based upon that, there is manual work that has been assigned, especially some of the menial works. right? Especially work that involves cleaning toilets, etc. That is mean that Supreme Court came down heavily in this, right? In this landmark judgment, Supreme Court strongly condemned the caste-based discrimination inside the prisons. The court observed that certain prison manuals in the different states assigned manuals or degrading work to the prisons on the basis of the caste, which is not allowed, right? The court held that such practices is unconstitutional. Literally, it is unconstitutional because it violates what? It violates Article 14, it violates Article 15, it violates Article 17 as well, right? And broader, if you look at it, entirely violates Article 21 of the Constitution, which is right to life and personal freedom. The judgment actually emphasized that even the prisoners retain their fundamental rights and cannot be subjected to the caste-based treatments. This is very important observation. The court directed the state to revise the discriminatory prison rules and ensure equality and dignity in prison administration, which is very important, right? Now, next question. It says reservation in promotion in consequential seniority in favor of scheduled caste and scheduled tribe, SCs and STs, is facilitated which provision of the Constitution? It is facilitated under Article 16(4)(a). Anyhow, the articles are closely related. It's a little confusing, but it was Article 16(4)(a). See, actual 16 talks about the Constitution talks about what? It talks about equality, right? Equality of opportunity in the matter of where? In the matter of public employment should be provided. Equality should be provided. So, Article 16 surplus 4A, this was inserted through the 77th Constitutional Amendment Act. Right? It empowers the state to provide the reservations in promotions of the scheduled caste and scheduled tribe when they are not adequately represented in the government services. That is very important. When they are not adequately represented, the promotion should be done. Later, the concept of consequential seniority was strengthened through 85th Constitutional Amendment Act, which allowed for the SCs and STs employees to retain the seniority from the date of promotion. Actually, this provision aims to promote social justice, adequate representation in the public employment. Right? Done? Now, let's see. The next part is that in which case one LKG student, which is a minor, filed a PL through his guardian seeking the removal of country liquor shop located next to his school premises. See, first of all, this is immoral. Liquor shop is located nearby schools or temples, etc. That is not allowed. Now, this case becomes notable because why? Because it is an young school students approached the court through his guardian to protect the school environment. That is very important. Now he is looking for a larger cause. That's why it is adopted as a PL, public interest litigation, right? This is PL, public interest litigation. Now this is for the safety of children's educational atmospheres, right? And also the public morality and near education institution concern. Actually, the court considered this issue seriously because the liquor shops near the schools actually negatively impact the students' discipline and the public order as well. The case is very important. How the public interest litigation can be used to protect the community welfare and children's right. That is very important. See, generally what happens is that in recent times, PL is used for it is also termed as private interest litigation, right? It is for the publicity interest litigation. So that is not the case. So in this particular case, it was about the liquor thing. Now what is right? Understood. Now which case it is? It is the Master Atharva Minor. And another was a state of UP. This is the case. Done. This is the 2020 case. Done. Chalo. Now let's see the next question. Under Article 76 of the Constitution of India, Dash shall appoint the Attorney General of India, who shall be the person qualified to be appointed as what? See, Article 76, it talks about the Union Executives, etc. Now, who will appoint the Attorney General of India? Attorney General of India is appointed by the President. Now, Attorney General of India, if he is to be appointed, then he should possess the same qualification as the judges of the Supreme Court. Now, what is the answer here? Now, President, judges of the Supreme Court. The qualification should be same as that of the judges of Supreme Court. Very easy question. Now, what is the judges of the Supreme Court qualifications is? Now, let's see that. Now, the judge qualification, it is one of the easiest qualification. You should be a citizen of India. Right. Next, he or she should have served the High Court judge for the least of 5 years, or at least practiced as an advocate in the High Court at least for 10 years. Either you have served in the 5 years or at least 10 years, or to be considered as a distinguished jurist in the eyes of the President. You are considered as a distinguished jurist in the eyes of President. In that case also it can be done. Right? Understood? Now let's see the next question here. We'll move to the next question. Yes, the question says, in which of the following cases the Supreme Court of India observed the doctrine of pre-decision hearing and post-decision hearing? Now this is observed in the Menaka Gandhi versus Union of India. Now what is this pre-decision hearing, post-decision hearing? Now this is one of the landmark judgments of Indian constitutional history. The case arose when the government impounded means here that Menaka Gandhi has been kind of confiscated, right? kind of restrained by the police people, and restrained the passport. People or the state restrain her passport, confiscate the passport without giving her prior notice or opportunity to be heard. So that is very wrong. Now this Supreme Court observed that this clearly violates her liberty to travel. That is under Article 21 of the Constitution. Right? What it says, it should be just, fair, and reasonable. Now, if you discuss this, what is a pre-decision hearing? Hearing a person before taking the action, and post-decision hearing is giving an opportunity to be heard under the urgent action has already been taken. And the court recognized that exceptional situations where immediate actions is necessary, a post-decisional hearing may satisfy the principle of natural justice. Right or not? At least if a person has been arrested, he should be given enough chances that to explain his position. Right? This judgment is greatly expanded in Article 21 of the Constitution and also the principle of natural justice. It expands the idea of principle of natural justice, right, and also procedural fairness, right? Understood? Chalo. Next question: by which constitutional amendment Article 51A subclause K was inserted into the Constitution of India? Now, it was inserted through the 86th Constitutional Amendment Act 2002. Right? It was inserted to the 86th Constitution. Now, what is the importance of this? Now, this clause introduced a new fundamental duty. Now, if you know Article 51A, it talks about the duties of the people. It talks about new fundamental duty for parents, guardians, etc. Right or not? Now, every parent or a guardian must provide the opportunity for the education to their child or a ward. It is between the age of 6 to 14 years. It is between 16 to 14 years. The amendment was very significant because it strengthened the constitutional commitment to education. The same amendment also inserted Article 21A, making the education a fundamental right. Education as a fundamental right, right or not? Education as a fundamental right, which is of between 6 to 14 years of age. Now, a modified version of this Article 45, which is of DPSP, relating to the early childhood education and care. So, 86th Amendment Act included a fundamental right, DPSP, and fundamental duty as well. Done? Understood? Yes. Now, what is the other amendments talk about? Here, 83rd Amendment talks about reservation matters in Arunachal Pradesh, so which is not much concern here. Next, 84th Amendment Act actually related to the delimitation. See, every after census there is a delimitation that has been taken up in the 84th Constitutional Amendment Act, and 90th Constitutional Amendment. This is 84th, and the 90th Constitutional Amendment Act. This is talking about the Assam. They dealt with the representation of Assam and how it is to be done. That is dealt here, right? Now, let's look at the next question. Now, the Supreme Court has overruled its decision in E.V. Chinnaya versus the state of Andhra Pradesh 2004 case relating to the subclassifications of the scheduled caste in the reservations, in which case. Now, this was taken up and overturned in the state of Punjab versus Devender Singh's case. Now, let's understand the significance of this case. Now, in E.V. Chinnaya case, 2004 case, the Supreme Court held that the scheduled caste form the single homogeneous group. Scheduled caste form the single homogeneous group. That was observation. They are the single homogeneous class, and the states could not create a subclassification. So, no subclassification was allowed after this, right? Now, however, in the state of Punjab versus Devender Singh, a larger bench of the Supreme Court overruled this, and they observed that the subclassification within the scheduled caste is constitutionally permissible, and states can identify the more backward or underrepresented groups among scheduled caste, and to ensure equitable distribution of reservation benefits. Right, equitable distribution of the reservation benefits can also be done. The judgment recognized that all SC communities do not enjoy the reservation benefits equally. They do not enjoy the reservation benefits equally, and some groups remain more disadvantages than others. So, subclassification is important. Right? So, the decision is considered highly significant for affirmative action in social justice. Done? Now, the next question, it talks about which article of the Indian Constitution deals specifically with the adjudication of dispute between water of interstate rivers or river valleys. Now, this is dealt under Article 262 of the Constitution. Now, 262 of the Constitution empowers Parliament to make. It directly empowers Parliament. Now, Parliament for what? it empowers the parliament to make adjudication of disputes relating to interstate rivers and river valleys, and it also allows the parliament to exclude the jurisdiction. Parliament can exclude the jurisdiction of the Supreme Court and any other court also. So using this, parliament has enacted one important act. Now the important act is interstate river water dispute act of 1956. Under this, special tribunals are established. Under this, special tribunals, where tribunals are quasi-judicial authorities, because parliament can also exclude the jurisdiction of Supreme Court or any other court in India, right? So they have done it, and under this, special tribunals were established, and the river water disputes between the states such as Kaveri water dispute, Krishna water dispute, Ravi, Bias dispute, etc. were taken up. Done. Now, what is the other articles talk about? Article 131, it deals with the original jurisdiction. It talks about the original jurisdiction of the Supreme Court, that is between center and the states, right? Article 263, it talks about the interstate councils, establishment of interstate council. President can establish this, right? Then Article 246, it is the seventh schedule of the Constitution that has been dealt here. The list is divided between three powers, that is center, state, as well as concurrent powers. So that has been dealt here. Done? Understood? Article next part. Let's see. In which case the Supreme Court held the rights to digital access is an intrinsic component of right to life and liberty, and directed the state to proactively design and implement inclusive digital ecosystem that serve not only the privileged but also the marginalized. Now this was dealt under Amar Jain versus Union of India and others case. Now this is a significant judgment. The Supreme Court recognized that in the modern digital age, now we are living in a modern digital age, right or not? Modern digital. Now modern digital age, access to digital, now access to internet also for that matter, and online services is closely connected with the fundamental rights under Article 21, because it talks about the liberty. Now court observed that digital access is essential for education. It is also essential for healthcare as well. It is also essential for welfare schemes. It is also essential for communication. It is also essential for participation in the public life. The court further directed the states here to create an inclusive digital ecosystem so that the technology advancement benefits not only the privileged sections of the society but also the marginalized and vulnerable groups. This is very important. The judgment reflects the constitutional principles of equality. It represents the principles of equality, dignity, inclusion, and substantial access to justice. Right, substantial access to rights as well. Done? Now, let's see the next question here. The Supreme Court first recognized that parliamentary privileges do not automatically override the fundamental rights, in which case. Now, this was dealt in Gumupati Keshava Ram Reddy versus Naifuzul Hassan case. Now, the case is important because Supreme Court acknowledged the parliamentary privileges. Parliamentary privileges are not completely absolute and cannot automatically supersede the fundamental rights guaranteed under the Constitution. Actually, the judgment emphasized there is a need to maintain the constitutional balance between the privileges that the people will get, that is especially the legislative principles, privileges, or the parliamentary privileges given to the members of parliament, and also the citizens' fundamental rights, right? The court indicates that the privileges of the legislature must still operate within the framework of the Constitution. It should be worked within the framework of the Constitution. Now, this case actually laid an important foundation for the later constitutional debates concerning legislative power, judicial review, and also for the protection of the individual liberties. Done? Chalo. Now, let's see the next aspect of the question, that is a bill dealing with which of the following does not constitute money bill under the Constitution of India. Now, the correct answer for this question is that imposition, abolition, remission, alteration or regulation of any tax by the local authority does not come under the definition of money bill. Now, let's see what is this. Now, Article 110, this is very, very important article. Article 110 of the Constitution, which deals with the concept of money bill. Now, here a bill is considered as a money bill only if it deals exclusive with the matters, which includes first, it includes the taxation matters of union government, taxation matters of the union government, or it includes the borrowing of money by the government of India, or it includes custody or withdrawal from consolidated fund of India, or appropriations of money, or related to financial matters. Now, when you look at the taxation, it is by the local authorities such as municipalities or local bodies, etc., which specifically exclude the definition from the money bill. This is why this particular fourth option does not come under the money bill matters. Done? Chalo. Now let's see the next question is that who called Indian federalism as cooperative federalism? This is very important. This is actually said by Granville Austin. Now, Granville Austin is a renowned constitutional historian. He is also a scholar, and he also has a scholar in Indian constitution as well. He described Indian federalism as a cooperative federalism because Indian constitutional system requires a union as well as a state to work together rather than function in a strict separation. Rather than they have to work together, right? See, for him, the constitution creates a balance. Now, balance of what? Powers are divided between center and state, and both levels of the governments cooperate for the national development and governance. This cooperation can be seen in the areas such as planning and development. For example, you can see in terms of GST, interstate councils, disaster management, and financial relations as well. So, even though Indian federalism is therefore different from the classical federal models because it combines a strong center and with an active state participation. Right or not? Now, what K.C. Weir says? K.C. Weir said, he said India is a quasi-federal with a strong centralizing tendency. That's what he said, right? And anyhow, B.R. Ambedkar did not given anything of this nature, but he's a chief architect of the constitution. But he did not coin the term as a federalism or cooperative federalism. Done? Now, the next question is, which of the following constitutional amendment require ratification by not less than half of the state legislature? Now, the correct answer for this question is 101st Constitutional Amendment Act. Now, what is this 101st Constitutional Amendment Act? It included GST, Goods and Services Tax. The amendment significantly changed the financial and taxation relationship between center and state, financial and taxation powers, because it affected the federal structure and distribution of taxation powers. It required ratification by half of the state legislature under Article 368 of the Constitution. Right? The amendment actually created GST Council. It introduced the concurrent taxation powers of center and state and transformed India's indirect tax architecture. Right or not? Now let's see the earlier amendments here. The first amendment is actually dealt with respect to land reforms, very famous. It dealt with respect to land reforms and it introduced 9th schedule of the Constitution, etc. Now, when you look at the 42nd Constitutional Amendment, it was taken up during the time of emergency, right? It is not among the amendments which require the ratification of the states, right? And 73rd Amendment, it is for the creation of the Panchayati Raj institutions, right? It is commonly recognized Panchayati Raj institutions, right? Understood? Chalo. Now, next question is, in which case Supreme Court laid down the rules in relation to doctrine of severability under the Indian Constitution. Now, the right option for this is RMD Chambar Bahuwala versus Union of India case. Now, what is this case says? Now, according to this doctrine, what is the doctrine? Doctrine of severability. Right? If the part of the law is unconstitutional, only that invalid portion can be removed, while the remaining portion is valid. Part of the law may continue to operate, provided the valid and invalid parts can be separated. Now, this was dealt in this particular case. Supreme Court laid down the important principles, whether the unconstitutional portions can be served or whether the remaining law can survive independently. The court explained that if the valid part can function independently and the legislature would have enacted it even without the invalid part, then only the offending portion should be struck down, right? Understood? Chalo. Now, next question is that the Supreme Court recently in the landmark decision held that governor's delay in granting assent to 10 bills as pernicious and illegal and granted assent to the bills which provisions of the Constitution was interpreted primarily here. It is Article 200 of the Constitution. Now, Article 200 of the Constitution deals with the powers of the governor. It deals with the powers of the governor regarding the bills passed by the state legislature. Under this article, the governor may give assent. He can give assent. He can say, okay, he can withhold the assent. He can return the bill for the to consider, and he can also reserve the bill for the president, right? In this landmark judgment, actually Supreme Court clarified the governor cannot indefinitely delay the action on the bills passed by the legislature. Now the court actually emphasized the constitutional authorities must act within the reasonable time, and the governor cannot use delay to obstruct the legislative process, right? Court also explained the prolonged delay as an unconstitutional and untimely granted assent to the bills. The judgment is considered as very important for the parliamentary democracy, for federalism, and also for the constitutional accountability. Done? Now, anyhow, the rest of the articles, Article 110, we have just seen, that is a money bill. Article 74 related to the Council of Ministers advice to the President, and Article 84 talks about the qualification of the members of the Parliament. Done? Next part. In which of the following case the Supreme Court has held that not all privately owned properties is a material source of the community in 8:1 majority. The case that is dealt is a Properties Owners Association versus State of Maharashtra. Now, what does it mean? The landmark judgment actually dealt with the Article 39B. It's a little complex concept, but let's understand this. Okay, which is a part of what? Which is a part of DPSP. Now, here the Article 39B actually talking about ensuring the ownership and control of the material resources of the community and distributed to serve the common good. Actually, Supreme Court clarified not entirely private owned properties can automatically be treated as material source of the community. The state can broadly classify all the private property under Article 39B for redistribution purpose. The court emphasized the constitutional balance between social justice and the protection of the private property. Actually, this judgment is considered highly significant. Anyhow, what is the material source and what is the private property, that is has given a little clarification by the courts here, right? Thank you for watching. Let's discuss the remaining questions in the next video.